Good afternoon, and thank you for joining CL Medilaw's Kids to Adults venue to virtual seminar on EHCPs. My name is Rachel Gibby. I'm a solicitor in the team at CL Medilaw, specialising in SEN matters. CL Medilaw are a team of brain injury and serious injury lawyers specialising in traumatic brain injuries, birth injuries, cerebral palsy cases, as well as court of protection and special educational needs matters, and welfare and benefits and wills and trust advice as well. So as a team, everything we do really is focused on changing our clients' lives and achieving the best possible outcome for them, whether that's getting the right compensation to ensure that they have the support they need, or getting the right educational provision in place. So today, of course, I'm going to be talking about EHCPs, so what they are, the content and what they should look like, the process for getting one in place, as well as some key points to look out for. But before I get started, I'd just like to show you a short video just to explain a little bit more about what CL Medilaw do and all of the ways that we help our clients and their families, featuring our client Jamie.
At CL Medilaw, we have always been driven by changing lives for the better. We are solicitors who advise and support clients with brain and other serious injuries. CL stands for changing lives. It's what we do, how we do it, and it's how we remember why we do it. So I'd like to pass you over to Jamie's mum Sharon now to show you how we achieve this.
We really thought that, well, maybe he will, make a really good recovery. We don't know that there's going to be, nobody had ever said that he was brain damaged or that there was going to be long-term problems. He must have had another checkup, and this was when Jamie was about 6 months old, with his consultant, and he sat us down and he said, Jamie has cerebral palsy. It wasn't until much later, and he was going to a childminder, and it was the childminder that actually put me in touch with Helen from CL Medilaw.
He had the MRI, and then the results came through, and to be told that if he'd have been delivered 15 minutes earlier, he would have been completely fine was awful. It was what we needed for his case, but to have that written in black and white that those 15 minutes meant what we have now compared to what we could have had. Sorry. It wasn't too long after that Helen phoned me and said, I've got really good news, the hospital have admitted liability, and I just broke down in tears. I was happy, I was sad, but it was what we wanted to hear, and it was just a weight off of our shoulders.
His bedroom is lovely, he's really comfortable in there. We take him then through into the hydrotherapy pool, which he loves. It's freedom for him, not being strapped into something, and is a real big change to his quality of life, that he can actually go in the pool and be supported by somebody but not actually be strapped into anything. It's lovely for him. The support doesn't stop there, it's ongoing. For example, we've just purchased a lovely converted American motorhome, which enables Jamie to still take part in a hobby that we've been doing as a family since he was born, motor racing. There are no facilities at the track that would support him. It does put your mind at rest that Helen and the team are there to look after his money and liaise with the Court of Protection to make sure that nothing happens to it. It's always there for him and for his needs. The outcome at the end is a positive one. We as a family are far happier, far less stressed, and it just has made our lives as easy and as best they can be given Jamie's condition. Having a child that's disabled affects the whole family, but now that we have a converted house, we have the motorhome that enables us to carry on with our hobbies as we want, we as a family unit are far stronger, far happier, and it's been well worth it.
At CL Medilaw, we understand that a settlement is not a win, but the start of a life-changing journey for our client and their family. We're committed to supporting you through that journey. We understand that for a parent or family member of a child with neurological injury or illness, the future can be a daunting prospect. Parents often tell us they worry who will support and protect their child when they're not there. We will always do our best to help with your real-life worries and needs, whether getting answers, compensation, or with care, education, deputyship or trusts. We can support you to ensure that your child is provided for the rest of their life. Please get in touch with us for free advice on your situation to find out how we can help.
So just before I move on then to talk about EHCPs, I just want to say that if anybody does have any questions while they're watching the talk about anything covered in that video or about EHCPs generally, please do post them during the talk, and my colleague Laura and I will be happy to answer those for you. So just to summarise a little bit about what I'm going to cover today. So I'll firstly talk about what an EHCP actually is and what it does, as well as who can get one. I'll then talk a little bit about what the contents of an EHCP should be and what it should look like. I'll go through the stages of the process of getting one in place, and then just at the very end I just want to give a very brief update about some changes that had been in place owing to the coronavirus outbreak. So just a couple of points about what I will cover. What I'm going to cover today is relevant for children and young people aged 0 to 25. So just to keep it brief, that is what I mean when I say child, and likewise if I say school, I mean school, nursery, college or other post-16 institution. And finally, just to say that the talk today is not designed to be any kind of advice, and there's an awful lot to cover on EHCPs in the next 25 minutes or so. So the talk certainly can't cater for every scenario, and it's just designed as a sort of whistle-stop tour of EHCPs, if you like. So if you do find that you need to take any action or have any concerns about an EHCP or the process, then just to note it's important to check the rules and exemptions and consider whether you do need to get advice. So what is an EHCP then? So they replaced statements of special educational needs, and all statements were to be transferred over to an EHCP by the 1st of April 2018. The purpose of an EHCP really is to set out the child's SEN, their special educational needs, the provision needed to meet those needs, and the outcomes for the child to achieve. So with EHCPs, there is more of a focus on outcomes, and when appropriate for older children and young people, preparation for adulthood as well. What's really perhaps key about the EHCP though is that it is a legally binding document, which means that once the plan is finalised and it's in place, then the local authority is legally required to ensure the SEN provision in the plan, and the child is entitled to receive that provision in law. So who can get one? So I'll go into more detail later on the criteria used to decide whether a child or young person needs an EHCP, but generally speaking, they are for children and young people aged 0 to 25 with special educational needs. So by child, we mean somebody aged 0 to 16, and by young person, we mean somebody aged 16 to 25. And that's an important distinction because it can affect the level of involvement that the person will have in the EHCP process. So what should it contain then? So the format and the appearance of the plan can vary somewhat between local authorities, but in law, a plan must contain these sections. So sections A to K are set out on these slides, must contain those sections, and they must be separate sections and clearly marked. So it must be clear exactly what's contained in each of those separate sections. So I will go through those sections A to K in turn, but broadly speaking, they cover the child's special educational needs and provision, the health and social care needs and provision, outcomes, and the placement for the child or young person as well. So starting with section A, so this is the views, interests, and aspirations of the child and their parents or the young person. So this can include their views and aspirations directly and their future goals. a summary of the child or young person's history, as well as detail of how they communicate, play and make decisions, for example, and it can also include a summary of their health as well, so it's fairly broad. Section B then is one of the really key sections of the plan, and this is the child or young person's special educational needs. So this must contain all of the special educational needs as identified in the local authority's assessment. So this could include things like how the child needs help to communicate, physical or sensory needs arising, or gross motor issues that, for example, need therapy input within the educational context. This section can also include health and social care needs where this is a special educational need, and that is something that I will come on to talk about more in a moment. But a good example of that is if speech and language therapy, for example, trains the child to communicate, then this can be seen as a special educational need, and if that is the case, then it must be included in section B. But again, I will come on to explain a little bit more about that in a moment. So section C then, sticking with the needs sections, is the child or young person's health needs relating to their special educational needs. So this needs to contain all of the health needs relating to the child's special educational needs as identified in the local authority assessment. So this could include things like mobility issues or the need for careful movement required within the classroom setting, for example. Worth noting that this is not just about general health needs, but rather health needs relating to the child's special educational needs. So the legislation contains a good example of this, being dental work. It's clearly a health need, but probably wouldn't be a special educational need. However, it's worth noting that the CCG, which is the NHS body which plans local health services, they can choose to include other health needs that, for example, should be coordinated in terms of an educational setting. So, for example, that could be where there's a long-term health issue that requires some coordination. And then section D, this is the child or young person's social care needs relating to their SEN or disability. So similarly, this needs to contain all of the social care needs relating to the child's SEN as identified in the local authority's assessment. It can also contain social care provided under a specific piece of legislation. And the local authority can again choose to include other social care needs, for example, where coordination of services is required. So that could be perhaps if a child in need plan is in place. Section E then is the outcomes for the child or young person. So this should be ambitious and set out the best possible outcomes to be achieved for the child or young person. The outcomes can be over varying timescales. So, for example, on one end, you could have important future transitions in the longer term, such as a move to a different school, or in the shorter term, you could have outcomes based on a specific communication goal to be achieved. The outcomes in the plan should also be SMART. So they should be specific. So, for example, a very particular communication target. They should be measurable. So we should be able to review the child's success or achievement. They should be achievable. So they should be doable for that particular child in view of their specific difficulties or disabilities. They should be realistic. So even though the plan aims to be ambitious, we shouldn't be setting up the child to fail. And they should be time bound. So there should be a clear idea of a time frame for progress or achievement. Moving on then to the provision section. So this is section F, so special educational provision, and this is one of the sections most frequently in issue for parents and young people. So this must include all of the special educational provision needed to meet the needs as identified in section B. So the two sections link together in that way. The provision must be detailed and specific and should normally be quantified and detail what exactly the provision will be, when it will be received, who it will be given by, and the duration. So, for example, we can often see things like a local authority saying that the child will have access to or will have regular physiotherapy, but this usually wouldn't be sufficiently clear. It should say whether, for example, the child will have direct therapy with a physiotherapist, or whether it would be provided indirectly by school staff, how many sessions they would have, and the duration of the sessions and when they would be received. There are some exceptions to this, so where flexibility is genuinely required to meet the child's needs, but this shouldn't be used as a replacement for the normal review process and should only be used where it's genuinely required by the child. It's also worth noting that Section F, as well as special educational provision, also needs to include health and social care provision where that educates and trains the child. And I'll again come on to explain a bit more about that in a moment. A really key point here is to note that the local authority is responsible for ensuring the provision in Section F once the plan has been put in place. The next provision section then is Section G, and this is health provision reasonably required by the learning difficulties or disabilities which result in the child or young person having SEN. So you'll note there that the wording is slightly different and says reasonably required, which means that there can be cost considerations in determining what is reasonably required for the child's health provision. So the provision here is designed to meet the needs as set out in Section C. So again, those two sections link together. And this could include things such as therapies or nursing support. Again, the CCG, the Clinical Commissioning Group, can choose to include other health provision, for example, to coordinate that with other services. And just as with Section F, the local authority has to secure the provision in that section, it's the relevant health commissioning body that has to ensure the health provision in Section G once the plan is finalised. Moving on then to sections H1 and H2. So these are the final provision sections, and these are the social care provisions to meet the needs in Section D. So this can include two types of provision. So firstly, social care required under a specific piece of legislation, and I won't go into too much detail about that today. And secondly, social care reasonably required due to the learning difficulties or disabilities which result in the child or young person's SEN. So again, with Section G, there's that reasonably required wording, which means there can be cost considerations involved. And an example of something that could be included in that section is something like support to find employment. Again, similarly to what I've just been through in the other sections, the local authority can also choose to include other social care not related to SEN to coordinate services, for example. So again, that could be where a child in need plan is in place. Then we have Section I, which is about the child or young person's placement. And again, this is perhaps one of the sections most in issue for parents and young people. So this should contain the name and type of the school, college or nursery or other post-16 institution, or sometimes just the type. Really important to note that this should only be named in the final EHCP and not in the draft. And this is essentially just so the local authority isn't making a decision about a suitable placement for the child without getting the views of the parent first. It's also key to note that in most cases where a school is named in a final plan at Section I, then the school has a duty to admit that child. So for example, where it's a maintained school. The only type of school that doesn't apply to is wholly independent schools. Section J then is personal budget. So just to explain a little bit about what that means. So normally a local authority will ensure provision in the plan by giving the funding needed directly to the school, and the school will make arrangements. However, they can also give funding to parents to arrange provision, and this is known as direct payments. So parents can request that the local authority set out a personal budget during the drafting stage, which is essentially the amount needed to put the provision in place. As part of IDing the personal budget, parents can ask the local authority to identify what part of that could be paid to them by way of direct payment. So it's really useful to note that that is a possibility, but I think also important to note that the local authority can refuse to do that on certain grounds. So for example, where it would be an inefficient use of resources to separate out the funding in that way. And the last section then is Section K. So this is the appendices. So this is essentially a list which must set out all of the advice and information gathered during the local authority's assessment, such as reports, assessments, things like that. Really important to note that this can include private reports and evidence from parents. So, for example, if a child has a private treating therapist, they may wish to include a report. And copies of all of the appendices will be attached to the final EHCP and essentially become part of the plan. So some key points to note just before I move on from the contents of an EHCP. So firstly, as I noted before, provision should be specific. So for example, it shouldn't just say that a child will receive physiotherapy, but rather they will receive a certain amount of hours per term, how often, and whether it is with a therapist directly and when. And that way, it's just simply much easier to enforce the provision in an EHCP if it's clear exactly what the child is entitled to. So very important to ensure that the provision is sufficiently specific. Secondly, it's important to note how the sections link together. So for example, section B, special educational needs, determined what special educational provision is required in section F, and that in turn determines what sort of placement will be needed at section I. So it's therefore really important, if, for example, parents have concerns about section I placement, that they ensure that all of those sections are correct and not just one, because they link together in that way. And thirdly and finally, it's also very important to consider whether provision, for example, therapies, educate and train is the wording of the legislation, educate and train the child, because if they do, then they need to be included in section F as special educational provision, as opposed to health provision, for example. Now, why is that important? Well, mainly because the tribunal, if you get to the stage of appeal, can only make binding decisions currently about sections B, F and I, so the educational provisions, sections and provision, and not about, for example, sections C and G, so health. So it can be really tricky to know whether something educates or trains a child, and it needs to be considered on a case-by-case basis. Generally speaking, speech and language therapy, for example, can very frequently be considered special educational provision. Physiotherapy and occupational therapy can be less clear, but certainly can be considered to educate and train the child. So for example, if occupational therapy were required for the child to do a particular learning activity, then that may be considered special educational provision. So just something to bear in mind if you are ever going through an EHCP. So now we've been through what an EHCP is and the contents, I want to look at the process for getting one in place. So there are 4 key stages, and I'll go through each in turn. So these are requesting an EHC needs assessment, the EHC needs assessment then being carried out, the draft EHCP stage, and then the 4th and final stage, finalising the EHCP. So in terms of the first stage, so requesting an EHC needs assessment, so parents, young people, schools or colleges can all request that the local authority carry out an assessment for a child or young person aged 0 to 25. In deciding this, the local authority will consider firstly whether the child or young person has or may have SEN, and secondly whether the child or young person may need SEN provision in an EHCP. So in this context, SEN means a learning difficulty or disability which calls for special educational provision. Well, what does learning difficulty or disability mean in this context? So it means if a child of compulsory school age or young person has a significantly greater disability in learning than the majority of same age peers, or has a disability which prevents or hinders them making use of facilities of a kind generally provided for others of the same age in a mainstream school or institution. So it's quite wordy, but essentially if those 2 tests are met, then the local authority must carry out an assessment unless it's carried out one within the last 6 months. And generally speaking, the local authority must communicate its decision as to whether it's going to carry out an assessment, generally within a maximum of 6 weeks from the initial request for an assessment. So the second stage then, if the local authority determines that an assessment is required, is to carry out the EHC needs assessment. So the local authority will gather information from the child or young person, parents and certain professionals to assess whether an EHCP is required. Again, it's worth noting here that parents can submit their own expert reports or evidence should they wish to. And the test in deciding whether an EHCP is required is where, in light of an EHC needs assessment, SEN provision is required to be made in accordance with an EHCP, the local authority then must prepare a plan. So it's quite a broad test, and in considering that, the local authority should consider whether the child has been making sufficient progress to date. Again, there is a time frame, so the local authority, following the needs assessment, should generally communicate its decision as to whether it's going to draft an EHCP within a maximum of 16 weeks from the initial request for an assessment. So if the local authority decides that an EHCP is required, the next stage is then to produce a draft. So this must contain the prescribed sections that I covered just now, so sections A to K. The local authority should then send a copy of the draft to a young person or parents for review and give them 15 calendar days to comment on the EHCP, seek agreement for personal budget and express preference for a placement as well. And they should also give them 15 calendar days to request a meeting. Really important to discuss at this stage and check whether the contents are correct. So are they accurate in terms of provision and need, and do they comply with the rules? So for example, is the provision sufficiently specific? Also worth reiterating that the name of the school should not be named in the draft to allow the parents or young person to provide their view before the plan is finalised. And then once the local authority and parents have had a discussion or meeting, if required, the local authority will then issue a final EHCP, and it must do so within 20 weeks of the initial request for an assessment. As I said earlier, once the plan is issued, the child is then legally entitled to the provision in the plan. So, but it is worth noting that the local authority can still issue a final plan if the draft wasn't agreed with the parents or young person. So in that scenario, if the parents or young person are still unhappy with the contents and have concerns, they may at that stage need to consider whether they need to make an appeal to the tribunal. So just to recap that timeline, so the total timeline of 20 weeks for the final EHCP from the initial date of requesting an assessment. There are some exceptions to this. So for example, if certain appointments are missed or a child is absent for a period, but generally speaking, the local authority must carry out the process within those timeframes. And I think it's worth noting as well that they are maximum timeframes. So the local authority should carry out the process as soon as possible, but certainly within those timeframes. So just very briefly, I just want to provide a little bit of an update on what has happened in light of the COVID-19 outbreak in respect of what I've just covered about EHCPs. So following the start of the pandemic, the government introduced some temporary changes to the local authority's duty to ensure the special educational provision in the plan. So the Coronavirus Act 2020 temporarily changed it to a reasonable endeavours duty. So what that essentially meant was that the local authority had to do what they reasonably could to ensure the SEN provision in the plan. So it changed their duty. So this came to an end on the 31st of July 2020, meaning the usual absolute duty applies again. And similarly, the SEND Coronavirus Amendment Regulations 2020 temporarily relaxed some of the local authorities' deadlines for the EHCP procedure that I've just been through, where it was not reasonably practicable to meet that particular deadline for a reason relating to the incidence or transmission of COVID. So an example was the 20-week deadline to issue the final plan. So instead, under that regulation and amendment, the local authority just had to carry out the particular step as fast as was reasonably practicable. So again, that amendment ceased to have effect as of the 25th of September. But I think just worth noting that these changes sort of had come into effect previously. Clearly the intention at the moment with the second lockdown is that schools and colleges are remaining open. So a bit of a different scenario, but I just wanted to mention that it's just worth keeping up to date with any sort of potential further changes if you do have a child or are a young person with an EHCP or are beginning the process, then the .gov website is useful for that. So just to summarise what we've talked about, I've talked a little bit about CL Medilaw and what we do, and then about HCPs. We've talked about what an HCP is and does, who can get one, the contents of an HCP and those specific sections that they need to contain, the process of getting one in place, and also a little bit of an update as well. So thank you very much for watching, and I very much hope that that information on EHCPs was helpful. If you do have any questions about brain injuries or serious injury matters, SEN, or any of the other areas that we covered in the video that we can help with, please feel free to contact us on the details on the screen now, and we'll be happy to help. Alternatively, please post a question while you're watching the video, and as I said, Laura and I will be happy to help. Thanks very much.